Law 578, Law of Evidence 2, Lecture 2, Witnesses, Competency, Compellability and Privilege. In our previous video, we have looked into the issues of competency, compellability and privilege. So today in this discussion, we are going to look into competency, compellability and privilege of the accused person giving evidence for himself. Now, the law providing for the accused person giving evidence for himself, you have that is under section 120, subsection 3 of the Evidence Act. If you look at subsection 3, in criminal proceedings, the accused shall be a competent witness in his own behalf and may give evidence in the same manner and with the like effect and consequence as any other witnesses, provided that, so far as the cross-examination relates to the credit of the accused, the court may limit the cross-examination to such extent as it thinks for proper, although the proposed cross-examination might be permissible in the case of any other witness. Now, subsection 3 to section 120 here gives you the provision or provides you with the provision that if you have an accused person, he can testify and he can give evidence for himself on his own behalf. Now, if you recall the position of an accused person giving evidence in the court, let's look at some example. Basically, when you talk about an accused person, remember, an accused person here, if at all he is giving evidence in the court, it has to be done at the defense stage. If you recall, when you talk about a criminal trial, criminal trial, you have prosecution stage. When prosecution stage, you have the prosecution witness in call, where the examination in chief done by the prosecution, and then cross-examination by the defense lawyer and re-examination by the prosecution. And of course, what happened here is that the court evaluate this particular evidence at the prosecution stage and come and look at it in the standard of prima facie. And upon proving that the evidence tendered by the prosecution's witness reached the standard of prima facie, what happens here is that defense will be called. So when the defense is called, you are moving on to the second stage of trial where you have the defense stage. Now, at the defense stage, this is where you have the accused person here allowed by the law to give evidence on his behalf, right? So here, he is now giving, he will be standing at the witness box. He will be subjected to by examination in chief by the defense counsel, cross-examination by the prosecution, and re-examination by the prosecutor. Re-examination by the defense counsel. And basically, at this stage, when he gives evidence in the court, section 120, subsection 3 says that yes, he is a competent witness, he can testify in the court, and he can be examined in chief, cross and re-examination in relation to his evidence. And basically, having said that, it is up to the discretion of the court to allow for a certain element of cross-examination, especially when you talk about the credit of the accused person. So it means that there's some degree of protection given by the court under section 120, subsection 3, where the court can limit cross-examination which relates to the credit of the accused person. Now, having said that, so if you have an accused person here giving evidence in the court, there is another protection that is also provided for to him, that is under section 132 of the Evidence Act. Now, so we have to cross-refer section 120, subsection 3 with section 132. But bear in mind, section 132 here is providing for the law against self-incrimination, whereby it also applies to all evidence taken by any witnesses. So it means that evidence against self-incrimination here is not limited to the accused person giving evidence in the court, but privilege against self-incrimination can also be accorded to any other witnesses testifying in the court. Now, what is Section 132? Now, let's refer to Section 132. The Section 132 provides for the privilege, evidence which are privileged against self-incrimination. Witness not excused from answering on ground that answer will criminate. Subsection 1. A witness shall not be excused from answering any questions as to any matter relevant to the matter in issue in any suit or in any civil or criminal proceeding upon the ground that the answer to that question will criminate or may tend directly or indirectly to criminate him, or that it will expose or tend directly or indirectly to expose the witness to a penalty or forfeiture of any kind, or that it will establish or tend to establish that he owes a debt or is otherwise subject to a civil suit at the instance of the government of Malaysia or of any state or of any other person. So what you have under Section 132 here, this is actually privilege against self-incrimination, whereby if you have either an accused person here giving evidence on his behalf, or if you have any other witness here giving evidence in court, the law says that if the question asked require an answer and the answer is incriminating against him, the law says that he is still compelled to give evidence in the court. Now, when you talk about evidence of self-incrimination here is, you have the position under the common law. Now, under the common law, which is provided for in the case of Blunt against Dark Lane Hotel, what's happened here is that if the accused person giving evidence on his own behalf, so he's the witness here, or any witness here testifying in the court, under the common law, if the questions put to them is incriminating in nature, they are not allowed to answer any questions, and they are not allowed to produce any document which are likely to incriminate him. So that is the position in common law. You have this in the case of Blunt against Dark Lane Hotel. Now, what does it mean is that if the questions open up the possibility of any criminal actions or any possibility of civil actions made against him, right? Civil action made against him, it means that the witness here, be it the accused person or any other witness, is allowed under the common law not to answer question, and he will not be subject to contempt of the court. Meaning to say that he cannot be compelled to give evidence in the court. There's a degree of privilege against self-incrimination in the sense that he is privileged from answering the question by the law against in giving any evidence that may be detrimental to himself. The position under the common law, however, is not the same with the provision under Section 132. Because if we read under Section 132, subsection 1 just now, we find that this particular provision basically removes common law privilege against self-incrimination. So it means that in this situation, under Section 132, subsection 1, you find that if the witness or an accused person is asked questions and the answer is incriminating, they will still have to answer the question. In fact, they are still compelled to answer in the sense that failure to answer may be subject to contempt of court, right? So that is the position under the Evidence Act 1950. How will this be so? Because if you refer to the provision under Section 132, you have the word a witness shall not be excused. So this means that he has to give evidence in the court even though it incriminates him. And then you refer to Section 132, subsection 2 here. No answer which a witness shall be compelled by the court to give shall subject him to any arrest or prosecution or be proved against him in any criminal proceeding except in a prosecution for giving false evidence by that answer. Now, section 132 subsection 2 here is basically saying that a witness may be compelled, right? A witness may be compelled by the court. A witness may be compelled by the court to give evidence in the court. Here it reflects that the court may put pressure on the witness who is sitting in a witness box and has taken an oath, and he cannot be excused to give evidence in the court. So it means that he can be subject to perjury here, right? So that is the position under section 132. Now the question now here, when we refer to witness here, under section 32, it refers to basically, you are basically referring to a witness here. Who are witnesses under section 132 of the Evidence Act? Now, section 132 of the Evidence Act here, witness here can refer to accused person giving evidence at the defense stage, giving evidence in his own behalf. So basically, you have this in the case of Television Broadcaster Limited against Mandatory Video Hotel. Because whenever he is in the position of a witness, he is in the position of furnishing evidence, right? He is in the position of furnishing evidence during that particular trial. That is why he is to be regarded as a witness. And of course, when you are referring to any other witness testifying orally in the court, that is also falls within the category of a witness. So this particular provision basically says that it has to be a person that is testifying in the court, then he is regarded to be a witness. It means that affidavit is not regarded as a witness, right? Affidavit is not regarded as a witness, yeah? So what happened? You have this in the case of PMK Raja and Worldwide Commodities, whereby affidavit is not regarded as a witness because it does not relate to an oral evidence testified in the court. Okay, so that is the position. Now, there's another sub-provision under section 132, that is under 32 subsection 3. This particular provision says that before compelling a witness to answer a question, the answer to which will criminate or may tend directly or indirectly to criminate him, the court shall explain to the witness the purports of subsection 2. Now, what does it mean here is that, so if you have a witness here, or you have an accused person here testifying in the court, or if you have a witness here testifying in the court, you may have prosecution here asking questions to the witness or to the accused person testifying in the court, and these two persons basically refuse to answer those questions because they are alleging that the question is actually tend to incriminate them. So what happened here is that the court may compel under section 132 for them to testify nonetheless. And it is a duty of the court under section 132 subsection 3 here to explain the effect of section 132, meaning to say that it is a duty of the court under section 132 to tell the witnesses and the accused person of the fact that if they testify in the court and they found to be not telling the truth, they can be subject to perjury. So section 132 here, section 132 subsection 3 here is referring to the court having a duty to explain. So you have the court here having a duty to explain the implication of section 132, right? So there have been quite a number of cases in which evidence, privilege against self-incrimination has been tried to be invoked by the witness. You have this in the case of Jagatesan. Yeah, Jagatesan, this is a 2013 case. Now what happened here is that you have an accused person here, right? Okay, this is the matter that has gone for trial, and this is a defense stage. So at the defense stage, the accused person here is calling a defense witness, right? This defense witness is testifying in the court. Now what happened here is that when the prosecution asks a question to this particular defense witness relating to his role in this case, the accused person in this case, the defense witness basically tell the court of the fact that I refuse to answer this question because my answer will be incriminating me. So that is the answer given by the defense witness here. Yeah. And in this case, what happened here is that the defense witness here is trying to invoke section 132. That is trying to invoke privilege under section 132, subsection 132, that is evidence against self-incrimination. Now, what happened in this case is that it is up to the court to decide whether the privilege against self-incrimination can be accorded to the witness or not. Now, what happened in this case is that, right, the defense witness in this case is trying to manipulate or mock the judge by trying to rely on section 132. So in this case, the court says that they are not going to invoke privilege against self-incrimination and compel the accused person to give evidence in the court. Otherwise, it will become basically a mockery in the system. So in this case, when the defense witness tried to invoke section 132, the court actually rejected that application so as not to allow the court to be sort of like, in this case, the statement we made was that you don't want the court to be used like a zoo. Yeah. So this is a situation where, well, the law will not going to allow the defense or the defense witnesses from manipulating it, relying on the evidence of privilege against self-incrimination, and refuse to testify in the court. Right? You have so many other cases where the court actually have refused to invoke privilege against self-incrimination, whereby you have that in the case of just now Jagatisan, and you also have the case of Prabha against Prabha, anak lelaki Sina Tambi against private prosecutor. Right? So this provision basically says that, right, if you have in a matter of defense witnesses or even the accused person giving evidence for himself, basically, of course, they are competent witness to testify, and they may have privilege against self-incrimination, but as a general rule, the law in Malaysia is that it is different from that position under the common law, and they will not going to provide privilege against self-incrimination. So it means that when you are asked the question, you have to answer it. Okay? Now, the second discussion that we are going to make in this discussion in this video is issues of compellability and privilege relating to affairs of state. Right? Relating to affairs of state. Now, what does it mean by this one? Right? Now, when you talk about issues relating to affairs of state, the relevant provision that you have to bear in mind is actually section 123 of the Evidence Act. All right? Now, let's look at section 123 here. Evidence as to affairs of state. No one shall be permitted to produce any unpublished official record relating to affairs of state or to give any evidence derived therefrom except with the permission of the officer at the head of the department concerned, who shall give or withhold permission as he thinks fit, subject, however, to the control of a minister in the case of a department of the government of Malaysia and of the chief minister in the case of a department of a state government. Now, what does it mean by this? Yeah. So if you look at this one here, if you have a situation where you are trying to get some kind of a document, right? And this particular document is made by the government. So it could be made by the state. Now, the issue here is whether the document can be tendered or whether the person who has that particular document can prevent from the tendering of the document by relying this to be affairs of state, right? By relying this to be affairs of state. Now, if you look at this one, what is the rationale of the privilege accorded by section 123 is that basically reliance of document being affairs of state is that because this is a privileged document. It cannot be tendered because it is matters of national interest. Okay, so this is a matters of national interest. Okay, now let's look at evidence relating to affairs of state. Now, under section 123, therefore, what happened here is that you may have a situation where you have the plaintiff here is suing the government. So the government could be the defendant, right? And the plaintiff here may want to rely on a document. This particular document is actually belonging to this government, from the government, which is actually the defendant. The issue here is that the government here refused to produce this document. And they refused to produce the document on the ground that the document is actually affairs of state. So they are relying on privilege under section 123. When can this particular document fall under within the category of affairs of the state? Therefore, the government here, being the defendant, is allowed not to tender this particular document being affairs of state. So we got to look at the conditions that is provided for under section 123. Now when you look at section 123, it means that no one shall be permitted. It means that this particular document cannot be produced as evidence in the court, right? If this document falls within the category of an unpublished official record. Yeah, it is an unpublished official record. It means that if it is a public document published openly, then there is no issues of section 123. There's no issues of affairs of state because public readily accessible to that particular information. Say for example, you have an Act of Parliament. Act of Parliament is readily available, can be accessed by the member of the public, so there's no issues of claiming affairs of state. What you're talking about under section 123 here, you are talking about an unpublished official record that is within the department itself. So you are talking about unpublished, so this is a public document which is kept in the government and it is not published. And number two is that this particular document, for it to subject to privilege under section 123, is that this particular document must relate to affairs of state, right? This particular document has to relate to the affairs of state. Now the issue here is that who will decide whether this particular document is affairs of state? So who will decide whether this particular document is affairs of state? Now when you look at the position of the law relating to affairs of state here, right? Originally, under the common law principle, in the case of Duncan and Carmel Laird, this particular case, right, says that whenever there is a document created by the executive or by the government, it is the privilege to be decided by the minister. So if the minister here producing a certificate saying that this is matters that is affairs of the state cannot be disclosed, disclosure will result in injury to public interest, then basically this case says that the certificate of the minister is conclusive. Yeah, affairs of the state is for the minister to decide, and the court cannot inquire or go behind the document to determine whether this particular document is affairs of the state. So that is actually the position under the common law. So let's look at here. So you have here, issue here whether it is affairs of state. So under the common law, you have that in the case of Duncan, right? Okay, it is for the minister to decide. If the minister produces a certificate, the certificate is going to be conclusive. The court cannot look behind this particular document to determine whether or not it is affairs of the state. This provision, however, this position, the common law, however, changed by virtue of the case of Conway and Rimmer. The case of Conway and Rimmer basically changed the position, saying that this happens in 1968, whereby in this case the court says that, well, affairs of the state, we cannot allow the executive to decide if there is a certificate. The certificate is not conclusive to say that it is a privileged document. The court can refer behind the state. So you're looking at here, the position where the court can refer and look at the things behind the certificate to examine whether the document in question is basically affairs of the state or not. So it is for the court to decide whether the claim of privilege accorded or a claim of privilege made by the minister is actually justified or not. Right? So it is for the court to decide. And how will the court decide? The court can either look at the document itself. So if it is still claimed to be affairs of the state, then the court will look at other evidence related to this particular document. What I'm going to impress here is that the position under the common law, which was stated in the case of Duncan in 1942, right? It may be backdated to the earlier position of the common law. It's actually changed in 1988 due to the decision of Conway and Rimmer, whereby now what amounts to affairs of state is not for the executive to decide, but for the court to decide. And what about the position in Malaysia? So, despite the provision in the section 132 saying that no one shall be permitted to produce, decision to decide whether it is affairs of state or not is actually under section 132, actually under section 123, falls in the hand of the court. So the court basically has a duty to determine whether a particular document is affairs of state or not. And this is actually illustrated in the case of B.A. Rao against Sapuran Court. Now what happened in this case is that, right, you have here, so this is a civil case. You have here the plaintiff. The plaintiff here is actually the wife of the deceased person. So she is suing on behalf of the dead husband. So she is suing the government. So she's suing the government for negligence. Right? So this is an action for negligence. So she's basically suing the government, and you have that. This is a hospital. So the co-defendant will be the government, which is the hospital, and you have the doctor here who is doing the operation on the late husband, and eventually he was found dead. Eventually he died as a result. Yeah. Now what happened here is that there is a possibility of negligence on the part of the doctor here. So internally, the hospital has conducted some kind of disciplinary inquiry into whether this particular defendant, which is a doctor, negligent. So there have been documents made by the committee of inquiry within the department. So you have committee of inquiry here, and this committee of inquiry has produced a report relating to whether this particular doctor is actually negligent or not. Now what happened here is that during this civil proceeding by the plaintiff against the government and the relevant the defendant, the plaintiff here the plaintiff here asked the defendant to produce the report made by the committee of inquiry, which may reflect whether the doctor is negligent or not. And what happened here is that the government, which is the defendant here, is claiming privilege under section 123 and saying that, I'm sorry, the report made by the committee of inquiry is actually privileged under affairs of state. So that is the facts of this case. Now what happened here is that in deciding whether this particular document is affairs of the state or not, the court says that, right, affairs of state is for the court to decide. So you have B.A. Rao. You have two here. So it is for the court to decide whether it is affairs of state. So it is the court to decide. So if the court decide that, by looking at the document that was produced, yeah, which is for the eyes of the court only in the beginning. So if the court decides that this is affairs of state, then it will go back to the defendant, so to the government or to the executive, to decide whether or not they will give consent to the disclosure of that particular document. So you have a situation here. So you have in BA Rao a document. The court will inspect this particular document. So upon inspection of this particular document, the court finds that this document contains affairs of state. Then the court will revert back to the minister or to the executive or to the department to decide whether they want to give consent or not to the disclosure. If they consent to the disclosure, then the disclosure can be disclosed. If the executive or the minister or the department says that I will not going to give any consent to the disclosure of this particular document, it remains affairs of the state, then there is no way the document can be disclosed, and section 114 subsection D, adverse inference cannot be invoked against that particular person for failure to produce this document. Okay? Now, if you have the document inspected by the court, right, and the court finds that it is actually not affairs of the state. So, if the court finds that this is not affairs of the state, meaning that the court is coming to a decision that this particular document is not a privileged document, what will happen is that the document must be made available. Yeah, must be made available to the other party. So the document has to be produced in court. So the decision to decide whether a document is affairs of state or not, it is for the court to decide. And the power for the court to decide whether it is affairs of state or not is actually governed by section 162 of the Evidence Act. Now let's refer to section 162 of the Evidence Act. Okay, you have here production of documents and their translation. Subsection 1. A witness summoned to produce a document shall, if it is in his possession or power, bring it to court notwithstanding any objection which they may be to its production or to its admissibility. The validity of any such objection shall be decided by the court. Right? So what happened here, yeah, right, is under section 162 subsection 1 here is that you have a particular witness here trying to obtain a document from a defendant, or this particular document here is summoned to give evidence in the court. So this particular document here, alright, this particular witness here is actually producing a document, yeah, whether or not they can produce a document, it is for the court to decide. So it means that the decision whether it is affairs of state, it is for the court to decide, and this will happen during the preliminary stage. So it means that, say for example, you have one particular witness, you are requesting a document from this particular witness, the witness refused to produce this in the court. So now you have to determine this during preliminary examination whether this particular witness must produce this document in the court or not. Whether the document that is protected by this particular witness here is actually affairs of the state. Right? Okay. Now, how will the procedure what will the court do, yeah, if you have this particular situation, right? Under section 162, subsection 2, right? So the provision that you got to do as to how will the court do is section 162, subsection 2. Let's look at subsection 2. The court, if it sees fit, may inspect the document unless it refers to affairs of state to take other evidence to enable it to determine on its admissibility. So it means that if you have, for example, one particular document, remember it is for the court to decide. Yeah, you look at section 123, you cross-refer to section 162, subsection 1. The court is to decide whether this particular document is an affair of the state, how will the court decide? The court can either look at the document. So it means that the court look at the document. So the document will be produced and given to the court. The court will inspect the document and give the decision whether it is affairs of state or not. If the court cannot be given this particular document by the minister was saying that, or the officer is saying that, I cannot even give this document to the court, then the court under subsection 2 to section 162 here can refer to any other evidence which relates to that particular document, right? That relates to the particular document. So you basically have this document here, that is document number 1, which is claimed privileged by the witness or by the government. And what happened here is that the court either inspect document number 1 or the court inspect other document which relates to document number 1 to see whether document number 1 here is actually affairs of states or not. Alright? So, now, the failure to produce this particular evidence for the court to decide whether it's affairs of state, then section 114 subsection G here, you can invoke basically adverse inference. Alright? Okay. Now what happened here? What happened if you have a particular document? So you have a document here where affairs of state is actually claimed. And this particular document has a certificate issued by the minister saying that this document is OSA, Official Secrets Act. So this particular document is claimed to be privileged under section 123, and there's also a certificate by the minister saying that it is an OSA. Now, the law says that certificate under OSA here has nothing to do with relevancy and admissibility of an evidence which is governed by the Evidence Act. You have this in the case of Takung Tabari. You also have this in the case of let's see, PP against Datuk Sahar Arfan. So what happened here is that in the case of Takung Tabari, and in the case of Datuk Sahar Arfan, you have basically the state ESCO meeting. In the case of Datuk Sahar, you basically have an allegation for corruption against the accused person. So the prosecutor wished to scrutinize the state ESCO meeting. Yeah, state ESCO meeting. That reflect maybe the existence of something that relates to corruption. So what happened here is that the defendant or the accused person here is claiming privilege over the production of this particular document. Because you have a witness here, which is the secretary of the state ESCO meeting here, is giving evidence relating to this particular document. So the defense here is claiming privilege under section 123. Now here, by reliance on section 162, sub 1 and sub 2 just now, it is for the court to decide on whether it is a privileged document or not. And the court says that by looking at the document, well, the document in the case of Datuk Sahar, yes, in the case of Datuk Sahar, basically the document was actually a privileged document. Matters contained therein are affairs of state, therefore privilege should be accorded in the case that. However, in the case of Datuk Sahar is that consent has been given by the government, which basically own this particular document to be produced in the court. So that is a situation where the privilege is actually waived in the case of Datuk Sahar by the witness here giving evidence in the court and producing this particular evidence in the course of his testimony in the court. So that is actually the case of Datuk Sahar. The case of Takung Tabari here is also another example where reliance on affair of state, and you have certificate produced by the minister saying that it is OSA, yes, subject to Official Secrets Act. Now what happened in this case is that the court says that even though you may have certificate by the minister saying that it is OSA, This is to confirm that is OSA. However, whether it can be produced as evidence in the court is a different issue and is still up to the court using the power under section 162 to determine whether the document is affairs of state or not. Alright? So that is the position on this part. Yeah. So what happened here is that, so when you have affairs of state, remember you have the common law position. Originally you have the position of however change under the common law, and in Malaysia we also, our position is also that the courts in Malaysia can rely on, or the courts in Malaysia has the power to decide whether a document is actually affairs of state or not. And remember, when we look at section 123, at the end of the day, if it is privileged document, then the court will give the baton to the executive to decide whether they want to give consent or not to the disclosure. And if they give consent to the disclosure, section 114G cannot be invoked. However, upon inspection of this particular document, the court found that this is not affairs of the state, then the document has to be produced to the other side as evidence in the court. Alright? So this ends the discussion on affairs of states. We will continue later on issues of professional and official communication.